Good morning and welcome to the Tom Brokaw News Center here at Universal City. I'm Conan. Nolan, thanks for joining us. Hope you're having a happy holiday weekend on this Christmas Eve. Joining us first is the Honorable Eleni Kounalakis, the Lieutenant Governor of the great state of California, the former ambassador to Hungary. Madam Ambassador, Madam Lieutenant Governor, thanks for taking the time. So you wrote a letter to Secretary of State Shirley Weber. I'll have you define it. It regards trying to take Donald Trump's name off the ballot in California next year.
When the Supreme Court of a state determines that a candidate qualifies as an insurrectionist and is therefore disqualified from being on the ballot, that is something that we have to look at here in California as well, because for that Supreme Court to make that determination is an important fact that even though it wasn't our Supreme Court, can still be used to make a determination at the Secretary of State level.
Right. For those who say, listen, it's not the role of judges to decide who people should vote for. And whereas this is a deep blue state, Donald Trump didn't come close to winning here in either of his campaigns. You still had millions of Californians who voted for him. You're comfortable in telling them, no, we're not going to let you cast a ballot for him.
Well, I think it's important that this is seen through the lens of a question of rule of law and not a political question. The Constitution has this provision. Colorado, going up to the highest level of the court, has made a determination that it disqualifies Donald Trump. I think that through the lens of rule of law, something that we know that Donald Trump, by the way, flouts at every opportunity, but the rest of us believe that we must adhere to in our democracy, that is the question before us, and that is the question that I've asked the Secretary of State to examine and determine.
Lieutenant Governor Eleni Kounalakis, thanks for taking the time.
Thank you for having me.
We get the take on all this from Jessica Levinson, professor of election law at Loyola Law School, and Michael Genovese, who's with the Loyola Marymount University, professor of political science and head of the Global Institute at LMU. Thanks to both of you for joining us. Jessica, your assessment of this effort to kick Donald Trump off the ballot in California?
Well, I think it's a very popular effort, but we really need to wait for the U.S. Supreme Court for guidance. Right now, we have the Colorado Supreme Court saying under the 14th Amendment, Section 3, that the former president is not eligible to be on their ballot. This is a decision based on the federal Constitution. It screams out for Supreme Court review and clarification. And frankly, I think that's really what we need. I understand in blue states that there are elected officials who will say, Colorado did it, now let's go for it. But I really think, again, we need clarity from the Supreme Court about what this section means.
Michael, people should know about the judicial restraint. It is normally not up to one branch of government to determine who holds the other branch of government or the office of the executive branch.
It would be quite unusual for the courts to say, yes, we're going to disqualify you from the ballot, partly because states and parties tend to do that. And so if a state wants to do that, it does have certain parameters, but it would really be undemocratic to do that and take the decision out of the hands of the voters. And that's where it belongs. Donald Trump will rise or fall on the basis of the voters, not the law.
For the judges to rule on this case, is it not important for them, maybe not part of the law in the way we're taught in civics how it works, but is it not important for them to understand the social dynamic? What could happen in the streets of American cities if indeed this Colorado Supreme Court were to be upheld?
Well, there's no doubt that they know that they're in a minefield, and one false step could really be explosive. But on the other hand, the courts have to do their job. It is their role. And while the consequences could be dramatic on the streets, either pro-Trump folks or anti-Trump folks might really get supercharged over this. The courts might want to take that into some consideration, but I don't think that that's their primary consideration. They want to know what the law says. They want to know what they are capable of deciding, and they want to know whether or not this is fitting for the judges to decide.
Jessica, how important is it for the Chief Justice to have a 9-0 vote?
Well, I think it's important, but I don't know if he can get there. And if I could play devil's advocate for a moment, maybe not with Michael, but with your question, we're talking about Section 3 of the 14th Amendment put into the Constitution after the Civil War. Is it democracy limiting? Absolutely. Is that the intent? Yes. Does that mean there's something wrong with it? No. This was intended to be there if the other guardrails fail. And I know this isn't a popular decision or opinion, and I think that the Supreme Court will have this in their mind, but if the Constitution still means something, then we have to enforce those provisions, even when they're not popular. When it comes to the Second Amendment, when it comes to the First Amendment, just because there may be something that's unpopular, we still read it, clarify it, and enforce it. And I think that if the Supreme Court were just to follow what the original intent was in this case, they would uphold that Colorado Supreme Court decision, but I don't think they will for all the reasons that you just talked about. I just don't know if this chief judge, who doesn't even sit in the middle of the court, if this chief justice will be able to count to 9. I think he might be able to count to 6. But I could be wrong. It depends on whether or not they rule, I think, on a procedural issue like rightness, then maybe you can get 9, or a substantive issue like whether or not this clause applies to the presidency. Then I don't know if you can count to 9.
I just keep thinking he can't let this be a 6-3 Trump, conservatives versus liberals on this court. He has to figure out a way where they speak with one voice, and to have a split decision would result in further degradation of their authority.
I think he is very much aware of that. Let's remember the last time that it looked like the Supreme Court put not just a thumb, but their entire body on the scale of a presidential election. That was the 2000 election, almost exactly 23 years ago. It was a 5-4 decision that essentially handed the presidency to George W. Bush, and they took a lot of flack for that. And that 5-4 fracture, I think, did hurt the court. I absolutely think Chief Justice Roberts is going to want to look to a big decision like Brown, where the Chief Justice got 9-0. It was so important that the Supreme Court spoke with one voice. I just don't know that he can get there in this particular court.
We can admit, though, or agree that what happened in the Bush v. Gore it's a different time today in terms of the tenor of the debate, the emotions of the two sides, the split politically in the country, and that, my guess, they will take that into consideration.
I think that's right. And let's also remember, to your point of what would happen if, in fact, the Supreme Court were to uphold the Colorado Supreme Court decision. In this case, we haven't even voted. So I think it would look even more anti-democratic for the Supreme Court. After Bush v. Gore, we had already voted. We were allowed to weigh in. Now, again, in my mind, is that a legal problem? No. Is it a political problem? Yes.
And Michael, finally, what do you think? 6-3, 9-0?
It's not going to be 9-0. I think Professor Levinson's correct, because the court is split just as the country is split. And so if you're going to go strictly by legal terms, I think that you can get us maybe 6-3, but that's about the best you can get.
Jessica Levinson of Loyola Law School, Michael Genovese of also LMU, thank you very much for joining us.